Imagine that you're walking in the supermarket on a floor that has just been cleaned, causing it to become wet and slippery. As a result, you unfortunately slip, fall down, and get physically injured. Do you think that you can sue the owner of the supermarket and claim for compensation for your injury? What if the cleaner had been instructed to place a warning sign on the floor in order to inform you that there is a potential risk that you slip and fall down? Is your injury still the fault of the supermarket owner, or is it your own? Now, what if you were not physically injured, but passers-by kept staring and laughing at you? Can you seek compensation for the feeling of shame and embarrassment that you felt? Well, these different scenarios are clear examples of civil wrongs, because negligence on the part of one person causes damage to another person's health, property, or dignity. Such scenarios, among many others, happen in day-to-day life, and that is why there is a need for a law that regulates such matters. Such law is what we call the law of tort, which mostly addresses issues pertaining to negligence.
The tort of negligence was established in the case of Donoghue and Stevenson, held in the House of Lords. Mrs. Donoghue went into a cafe with a friend. The friend brought her a bottle of ginger beer and an ice cream. The ginger beer came into an opaque bottle, so the contents could not be seen. Mrs. Donoghue poured half the contents of the bottle over her ice cream, and also drank some of the contents. After eating part of the ice cream, she then poured the remaining contents over the ice cream, and a decomposed snail emerged from the bottle. Mrs. Donoghue suffered personal injury as a result. She commenced a claim against the manufacturer of the ginger beer. Her claim was successful because there was a duty of care that the manufacturer should have exercised, since it was reasonably foreseeable that the opaque bottle could contain something unusual. So the duty of care was breached, resulting in personal injury. Lord Atkin then established the neighbor principle, which basically tells us that one should do or avoid doing anything which one can reasonably foresee would likely cause injury to one's neighbor. And by using the word neighbor, Lord Atkin meant, I quote, persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omission which are called in question.
This case has been a turning point for the tort of negligence, and since then, the neighbor test has been applied whenever a negligence case emerges. However, much ink has been spilled on whether the tort of negligence is still in line with the rapidly evolving world we are living in. Well, this is the question that I, Lucien Loiseau, and my fellow teammates will be trying to answer in this video.
Good morning, I'm Jab Yitong. The first point to show that the tort of negligence is still relevant is in the area of economic loss. In this area, it is still considered highly relevant because the principle established in the past still apply in recent cases. Besides, the expansion of the liability for pure economic loss has actually helped to aid people in claiming for the losses they suffered.
The decision of Murphy and Brentwood made by the House of Lords still apply for laws caused by negligent acts nowadays. Murphy's case was once revisited in the case of Tesco Stores Limited and Costain Construction Limited and others. In 2003, this case, Tesco alleged that the absence of fire extinguishing measures was the cause of the spread of fire in one of their stores. Yes, the claim was concerning of the liability of the design of the building by the architects. The Technology and Construction Court held that the Costain company owed a duty of care in negligence as a competent contractor to avoid personal injuries and damage to other properties. However, the architect did not owe a continuing duty of care to review the building design. Derived from the Journal of Marcassinis and Deakin in 1992, they stated that, ironically, despite the fact that the builders may now escape liability in negligence whenever there is no injury to health as a result of negligent construction work, there is still the possibility of a claim in nuisance if adjoining in land is threatened, and of highway nuisance for which liability may be strict if there is a threat to people using the highway. Expansion on negligent misstatements had been made in the 1990s. Employment references and the wills cases were the expansion made due to the fact that they were not fit in the case of Hadley and Burns at first. For employment references, it can be well illustrated in the case of Spring and Guardian Assurance. In this case, Mr. Spring had been employed and later sacked by Guardian Assurance. He was then being offered a new job and asked Guardian for reference.
You want to hire Mr. Spring? Here are my comments.
However, Guardian had written bad comments about Mr. Spring and the job was withdrawn.
These are some unflattering remarks. I know, right? I guess I'll be hiring him after all.
Mr. Spring sued Guardian Assurance and he succeeded. The House of Lords stated that there was a duty of care, and obviously Guardian Assurance has breached it. And this case does not fit perfectly into the case of Hadley Burn because the information which caused the loss was not given to the person who suffered economic loss by it, but it was about him. It is hard to be fairly stated that there is a voluntary assumption of responsibility in this situation, because if Guardian Assurance if they refuse to give any reference to the company, then it shows that they are hiding something from the company about Mr. Spring, and this will eventually reflect a bad image of Mr. Spring. In the case of White and Jones in 1995, it created a clear picture for the wills cases as an expansion in the liability for the economic loss. In this case, a quarrel was erupted between the father and his two daughters, and he decided to cut them out in his will. After they settled down with the arguments, the father actually instructed the solicitor to amend his will, leaving £9,000 for his daughters. A month later, the will is still not amended, and the father actually reminded the solicitor to amend his will. Eventually, the father died. When the father died, the will was not amended, and the daughters could not legally inherit the money, and the solicitor was sued. The House of Lords allowed the claim. Lord Gough stated that there is a lacuna in this area of law, which was the solicitor only had assumed responsibility toward the testator. This loophole should be filled by extending the responsibility to the beneficiaries as well.
Hi, my name is Ng King Sit, and today I'm going to talk to you about medical negligence. So what is medical negligence? Well, medical negligence is when medical practitioners fail to provide the standard of care which is expected in each case, thus resulting in death or injury of the patient. In the UK, the NHSLA's annual report and account shows that there's been a 30% increase of negligent claims from 2009 to 2011. So, how does one pursue an action in medical negligence? Well, firstly, the plaintiff must show that the doctor owes the patient a duty of care, and whether the doctor is in breach of that duty, and did the patient suffer harm from the breach of duty of care. So, why is there a need for medical negligence, and is it still relevant today? So one of the reasons is to keep all medical practitioners accountable. Here's a short clip of the case of Kaunan Singh and Nagama and others.
Doctor, I think the plaster is too tight and I'm feeling quite painful. Can you do something about it?
I think some of this penicillin will help you. Yeah.
Are you sure this works?
Of course.
Alright, I'll try it.
In the case of Kaunan Singh and Nagama and others, the plaintiff was involved in an accident and his left leg had to be plastered. It was plastered too tight and he complained of the pain to the doctor. However, the doctor did not act on the complaints immediately, and the gangrene formed and his left leg had to be amputated. In Bolam's case, the judges held that a doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that particular art. So in the Bolam's case, the claimant lost. In the case of Karan Singh and Nagama and others, the Bolam's test applied. The judges held that the defendant was liable as all doctors were aware of the fact that if plaster was tightly applied, blood circulation will be affected, and the doctor was negligent when he merely prescribed painkillers when the plaintiff complained of the pain. Another reason for why is there a need for medical negligence is to compensate the harm of injury or death by the breach of duty of medical practitioners. Here is a short clip of the case of Tracy Hassel at Hillingdon Hospital.
Is this operation completely safe?
Don't worry, it is.
I'm going to sue you.
As seen in the case of Tracy Hassel and Hillingdon Hospital. In this case, Mrs. Hassel had a C5 and C6 decompression and disc replacement surgery, which was performed by Mr. Sean Ridgway, who is a spinal orthopedic surgeon. Mrs. Hassel suffered a spinal cord injury during the operation, which has rendered her permanently disabled, and therefore she is unable to work forever. Mr. Ridgway did not warn her that the operation might leave her paralyzed and did not discuss other conservative treatments before the decisions to have the operation was made. In this case, the judge finds that Mr. Ridgway used reasonable care and skill in carrying out the operation. And unable to identify the cause of Mrs. Hassel's spinal cord injury, the judge finds that Mrs. Hassel did not give informed consent to the operation, and that if she had been given information about material risks and conservative treatments, Mrs. Hassel will not have agreed to the operations. And the judge finally gave Mrs. Hassel a £4.4 million worth of damages. From the above discussion, we could see that medical negligence is still very much relevant in today's society, as it enables patients to have some sort of assurance that their doctors are accountable for their actions, and the patients are in good hands, and so guides medical practitioners in the medical field to develop in the right way. Above is my part of the presentation. Thank you.
So we all know that negligence is an important part of protecting human life. But what happens if that human life is a lot more vulnerable than you think? Enter care homes. Now care homes are there, as you can presume, to help you take care of the elderly. And with figures on the rise showing a huge number of old people being unable to live independently in the near future, families will have no choice but to place serious trust on these care homes so that they'll be able to do their jobs properly. And these jobs encompass a lot of things too, such as food, hygiene, and medical needs. This can be seen in the case of Mama and Beachfields, where an old lady actually developed bed sores and then blood poisoning, causing her to pass away due to the neglectful attitudes of the caretakers who did not provide these basic medical checkups for her. Now in the case of Dean and Prime Life Limited, what happened was that the plaintiff's husband was placed in a care home but was found dead later after 2 weeks due to the fact that he was having pneumonia and a broken hip. And this was pretty foreseeable considering the fact that the plaintiff's husband already had dementia, and at the same time it was due to the lack of surveillance that directly led to the plaintiff's husband's death. Now clearly coordination becomes an important part when it comes to controlling the situation within care homes. In the case of Fisher and Peregrine, what happened was that the plaintiff was harmed by another patient within the care home where he was placed, and it was due to the negligent understaffing of the care home itself which led to this harm. Now this clearly shows how important it is for care homes to have consistent upkeep as well as proper management in order to ensure that negligence doesn't occur out of one small mistake by the care home itself. So why is there such a wide range of duty of care? Well, due to the natural impairments suffered by the elderly, they have no choice but to depend on others for their own protection. And This is accredited to the mental and cognitive problems that they suffer. In fact, research has already shown that 70% of the elderly are actually right now experiencing dementia. And records are all kept in order to take into account all of these factors that will affect the elderly. And each individual elderly actually has their own specific record that demonstrates how serious the gravity of harm towards them can actually be. That's why, depending on the condition of the elderly, no matter what, however, there's going to be an increase in the gravity of potential harm that could come to them, which makes the harm all the more foreseeable. That's why caretakers have to take into account all of these factors and not underestimate even one of them, because it may cause serious damage. At the same time, to establish a link between the caretaker and the elderly, the but-for test is used in order to establish causation. Because it's pretty clear that caretakers are always directly involved when it comes to the elderly, because they are there to supervise their action and at the same time to provide guidance.
Now, even though caretakers were actually the ones who are responsible for causing harm to the patients of the care home, the one responsible for such negligence are actually the care home owners themselves. And this isn't just a matter of throwing responsibility around under the concept of vicarious liability either. In fact, the truth is, care home owners have a job in making sure that the standards of the care homes are properly reached as reasonably expected from a customer in order to ensure its competence. This is because customers are, after all, the ones that place their significant relatives under the care of these places. So at the end of the day, care homes are actually the ones that sets out a proper organizational context through parameters as well as constraints in, well, deciding how individuals will be able to carry out their work within the care home itself. Even Regulation 23 of the Health and Social Care Act 2008 sets out rules that care homes have to follow, that is proper background checking as well as staff training, which clearly shows how important it is to ensure that care home owners actually take their jobs seriously.
This can be seen in the case of Woodland and Essex County Council, where a schoolgirl actually suffered brain damage and was able to sue the local council who was in charge of the school instead of the school itself. In some cases, local councils are the ones that end up being liable instead. This is because in terms of publicly funded care homes, the local councils are actually the ones in charge of the placement of the elderly into these care homes and making sure that the needs are actually sufficient. Now, this might seem like a bit of a stretch, but the truth is, when harm actually comes to the elderly, the local councils will actually be the ones liable, as they were responsible and they were the ones that placed these vulnerable members of society, in this case the elderly, into a more vulnerable position, causing them to experience harm.
Greetings to the ladies and gentlemen of the panel. My name is Nishan, and today I'll be talking about police liability in the tort of negligence. Basically, there are special rules which apply to the police when it comes to their liability in the tort of negligence. These special rules apply to different scenarios, and these scenarios can be boiled down into basically two categories: one of operational matters and one of public policy matters. Operational matters are basically the methods in which police perform their duty, whereas public policy matters are basically the standard protocols such as task priorities as well as the location of manpower and money. In the public policy matters, the omission principle is applied, whereby a police holds no duty of care to protect someone from harm except those caused by itself, with the exception of special circumstances. In the case of Hill, Jacqueline Hill, a student, was brutally murdered by a Yorkshire Ripper. Later, after the Ripper was apprehended, it was discovered that the police were inefficient in piecing together the evidence, which may have led to an earlier arrest of the Ripper, and Jacqueline may have not died. Susan Hill, Jacqueline's mother, decided to sue the police on the grounds of negligence. However, the courts decided to dismiss her claim. This is due to several reasons. The first is that by allowing the police to be liable for negligence, this will lead to floodgates opening and the police being able to get sued for all kinds of minor infractions. This will result in the police being unable to perform their duty of investigating and suppressing crime efficiently. Not only that, but in order to handle the multiple claims, the police have to divert their resources from investigating and suppressing crime to fighting off these claims. As such, the courts set a precedent using the Hills case in order to create a blanket immunity for the police when it comes to negligence in public policy matters. This all changed in the case of Osman. In Osman, Mr. Osman was killed by Pager Lewis, a man who had been stalking and obsessing over his son. Previously, Mr. Osman and his family had reported Pager Lewis to the police. However, the police only interviewed him twice before releasing him. This ended up with his son being injured and Mr. Osman dead. Mr. Osman's widow, Mrs. Osman, decided to sue the police on negligence. However, thanks to the Hill's immunity, the court decided to toss away the case. Not giving up, Mrs. Osman decided to bring the case to the European Council of Human Rights, ECHR. The ECHR decided that this was a breach of Article 2. Article 2 is the right to live. As the police had known the threat to Mr. Osman and his family, they should have done reasonable steps in ensuring that they wouldn't have been harmed by Paget Lewis. Thus, the ECHR decided to bring up Article 6, the right of fair hearing, whereby Mrs. Osman was allowed to bring a case to court. The Osman case marks a turning point on the police reliance on the Hill's immunity when it comes to avoiding liability for negligence. In the past, police used to use the Hill's case in order to avoid any liability, even in special circumstances where there is positive police misfeasance. Now, with the Human Rights Act in place, there's an alternative to bring police to court for any negligence caused by them. However, on the other hand, this shows that tort of negligence is not as useful or relevant when it comes to holding the police liable for negligence. Osman case would directly impact future generation of cases. For instance, in the Malaysian case of Susanna, the plaintiff's husband died while under police custody. This led to the plaintiff, Susanna, suing the police on the grounds of negligence. The Malaysian courts decided that the police were responsible for the plaintiff's husband's death under negligence. This is due to the fact that the courts followed the Human Rights Act under the Malaysian Federal Constitution and decided to give compensation to Susanna. However, this view is not held in UK courts. In the case of Brooks, the plaintiff sued the police on the grounds that they treated him roughly during interrogation. However, the courts this time the courts decided that the police do not owe a duty of care in ensuring that the plaintiff was comfortable during the interrogation process. On the other hand, in the case of Smith, Mr. Smith, the plaintiff, received death threats from his ex-colleague. Although Mr. Smith reported to the police about these events, the police took no action in protecting him, and later Mr. Smith was assaulted by his ex-colleague. However, the courts also held that the police owed no duty of care in protecting Mr. Smith from his ex-colleague. Thus, in the UK, it is shown that the police owe no duty of care when it comes to negligence unless special circumstances apply. And here's the thing. Until now, it is still not defined what is special circumstances and how it is applied in this case. As such, although Human Rights Act allow the police to be brought to court for negligence, it is still not possible to sue the police on the grounds of negligence when it comes to public policy matters. Nevertheless, there's an exception to the omission principle for police liability in negligence. The Hills case only provides protection for the police for claims against negligence when it comes to matters of public policy, but not operational matters. As such, it is still possible to sue the police on grounds of negligence when it comes to operational matters, as is shown in the case of Robinsons. In the case of Robinsons, an old lady by the name of Mrs. Robinsons was knocked down by two police officers as they attempted to arrest a suspected drug dealer. Mrs. Robinson claimed for compensation from the police, and the courts held that the police owed duty of care to Mrs. Robinson and has to pay the compensation to her. This is because Mrs. Robinson was in the proximity of the arrest, and it should have been foreseeable that damage could have been caused to Mrs. Robinson while they were attempting to arrest the drug dealer. Robinson acts as a good reminder to police officers that their actions and decision making are not beyond reprimand and can be kept in line through private tortious actions, especially when it comes to operational matters.
For the final point against the relevance of the tort of negligence, I'll be talking about the Human Rights Act 1998. The HRA 1998 is increasingly becoming an effective alternative to the tort of negligence. Today, there are many negligence claims that are brought under the HRA instead of the tort of negligence because the likelihood of success is higher. To support this point, we will be having a look at the case of Osman and UK. In this case, Ahmed Osman was the 15-year-old student of Mr. Paget Lewis, a teacher. Mr. Paget Lewis started to develop an unusual and exaggerated attachment to Ahmed Osman, taking photos of him, following him home, and preventing him from talking to his male classmates. Ahmed Usman and his parents informed the police and many complaints were sent. However, the police failed to act on time and Mr. Paget Lewis continued to aggress the Usman's family until he eventually went to the Usman's house, took a gun and shot, injuring Ahmed Usman and killing Mr. Usman, the father of Ahmed. Mrs. Usman and her son brought an action against the police. They argued that the police had been given enough information about the danger that Mr. Paget Lewis posed to their family, but the police failed to apprehend the criminal on time. However, the Usmans appealed to the European Court of Human Rights in Strasbourg, where it was held that such police immunity is a breach of Article 6 of the ECHR. Article 6 gives people the right to a fair hearing before an independent and impartial tribunal within a reasonable time. Therefore, from the facts just mentioned, it is clear that the Usmans' action failed when they used the argument of police negligence. However, they were successful when the action was brought before the European Court of Human Rights in Strasbourg. This puts the relevance of the tort of negligence in question. Now, when it comes to private nuisance, actions brought under the HRA also tends to be more successful. Just like in the case of Dennis and the Ministry of Defense, where the claimant was disturbed by the noise of aircraft in a military base. However, it was held that this was interfering with the defendant's human rights under Article 1 and Article 8, that is his private rights. It is clear that the HRA 1998 challenges, interferes, if not conflicts, with the tort of negligence and other areas of tort law. That is why Lord Pickham of Cornhill came up with the following obiter dicta in the case of Van Cole and Chief Constable of the Hertfordshire Police. And as you can read, he says, one would normally be surprised if conduct which violated a fundamental right or freedom of the individual did not find reflection in a body of law as sensitive to human needs as common laws. From the facts enlightened in this video, it can be said that even if the tort of negligence is not applicable under certain circumstances, it is still relevant today, as it helps promote justice by providing appropriate compensation for losses suffered due to negligent acts.
While in the past, the probability of successfully claiming for pure economic loss was negligible. Today, such claims are recoverable under certain circumstances, especially when there is fiduciary relationships between the parties.
And as for vulnerable groups, authorities will definitely have to take more responsibility because these groups are a lot more vulnerable and thus they will have no choice but to ensure that they are safe because one single misstep can definitely lead to damages which cannot be compensated for.
In medical negligence laws are still very relevant today, as it keeps the doctors accountable for their actions and it provides better quality treatment. And for the patients who suffered harm from medical negligence can be compensated sufficiently.
When it comes to holding the police liable for negligence, it is said that certain special rules are held for different circumstances. These special rules should be elaborated upon so that in the future a clear guideline can be set as to when or when not a police is held liable for negligence.
Well, to make sure that the relevance and importance of the tort of negligence is maintained, the scope for the recovery for damage should be expanded. Only then can we as future lawyers and the general public envisage brighter gleams of hope for the proper upholding and establishment of justice in this area of law.
Take care.